So, hi, my name is Kip Needham. I am the Assistant Dean for Entrepreneurship Initiatives at Carnegie Mellon and Director of Project Olympus, where we run the startup programs, the incubators where we work with startups at the earliest stage, student, faculty, staff, high tech, low tech, no tech, whatever. And we have been producing this Start Smart series for probably in double digits by now. I can't remember how long.
It is, believe it or not.
Yeah. And this is our last one for the semester. So let me introduce my partner in crime here, Stephanie. You want to introduce yourself?
Sure. I'm Stephanie Dangle. I'm a professor of practice at Pitt Law School, and I teach a variety of law and innovation courses, as well as running our externship program there.
Okay. And we also partner with the Pitt's Big Idea Center. And Jess, you want to?
Hello, my name is Jess. I'm the manager for student programs and operations at the Big Idea Center. We're part of Pitt's Office of Innovation and Entrepreneurship, and we are the hub for all things student innovation at Pitt. We just got a new space. Come and visit 3601 Forbes Avenue. We also have a lot of cool programs going on, and a specific plug I have, if you're interested in anything that I just said or anything that we do at the Big Idea Center, we have our Big Idea Student Innovation Showcase next Tuesday at 5 p.m. Anyone's invited. We are sending out invites to members of the community and students and our competition mentors and affiliates, as well as our student team. So it's sure to be a good night. We're going to highlight everything awesome that happened throughout the year. And yeah, that is Tuesday, April 18th at 5:00 p.m. in Alumni Hall, Connolly Ballroom. So if anybody's interested.
Do they need to register?
What?
Do they need to register?
I can provide a link, but there will be walk-ins available. But I'll put a link in the chat box.
Okay. So I'm just going to do a brief shout out to Don Morrison because he's an EIR for over at Pitt, but he's now CEO of a new startup in there. But he's good at everywhere, and he's almost informally part of the team. So I'm not going to. One of the things that we always do in these, because it's part of the Connect series, is that this is an opportunity for startups, anybody actually, who is looking for a team member, anybody who's looking to join a team, if you have any announcements or you need help with anything. This is an opportunity to do a shout out to the people who are on this, who are logged on. So I'm just if you have something that you want to either announce or ask for, just unmute yourself and let it go. Usually I have somebody I can pick on, but I don't recognize the names to get it started. Okay, well, I'll just do my ask. Please come to our show and tell this Thursday over in the Pepper Quad Schwartz Center. Starts at 4 p.m., 4 to 6. So that's my ask. Okay, so I'm going to turn this now over to David Lehman, who is with K&L Gates, and he will introduce himself as well as his panel.
So good evening, folks. Nice to see everybody. This is one of our favorite presentations because we get to talk about all the things that for change that our clients have made mistakes, and we get to talk about it without attribution. And obviously, every one of them, as we were talking about earlier, were done before they engaged us, because that was by definition, or against our advice, one or the other. But anyways, so I'm David Lehman. I'm with K&L Gates. I've been there for way too long, according to them. And a lot of my practice deals with working with growth companies and startup companies and watching them grow from the very beginning to some kind of exit, hopefully a sale or something where they can make huge amounts of money, but also make big contributions to society. It's kind of cool. It's great business. So let me not say much more about that, but let my colleagues here introduce themselves. So let me start with maybe Deborah. Do you want to introduce yourself? You're on mute, Deborah.
Sorry about that. I'm Deborah Walker. I'm in-house legal counsel with Innovation Works. which is a local economic development nonprofit. We invest in and provide assistance to startup technology companies in southwestern Pennsylvania. And I've been practicing there since early 2006. And before that, I was with Morgan Lewis for a few years. But that's me in a nutshell.
Thank you. And doing great work in innovation work, that's for sure. And it plays a pivotal role in this community, that's for sure. Dave Kalson.
Thanks, David. Hi, everyone. I'm David Kalson. I'm a partner at Dentons, Cohen, and Grigsby. For about 35 years of my career, it was Cohen and Grigsby. Like David, we've been around the block a few times. And a little over 3 years ago, we combined with Dentons, which is the world's largest law firm. No offense to K&L Gates, we've got 13,000 lawyers in over 85 countries. It's been quite a trip being part of this firm. And I run the Venture Tech Emerging Business Group in Pittsburgh. I'm a national co-leader. And like Dave, I've been working with early stage companies, spinning them out of CMU and Pitt for the majority of my professional career, which has been incredibly satisfying. And I'm going to also throw in kudos to Deborah Walker, because she's played an incredibly important role in helping to launch and grow these companies over the years. The Pittsburgh technology ecosystem is robust, but it's a little small, and we all know each other, and we've worked with each other over the years, and that's all to the good for the companies that come out of Pittsburgh.
Absolutely, absolutely. All right, FJ, that sets you up.
Okay, so yeah, I'm FJ Lucchino. Like the other lawyers you've just heard from, I work with a lot of startups, a lot of technology startups. And unlike the ones you heard of, you've got some of the largest firms in the world, or the largest, and I'm a one-person shop, so maybe I'm tied for the smallest law firm in the world. And so in any event, but I do a lot of what Dave and Dave do, and I also get to work with Deborah Walker as well. And I'll pile on. Yes, Deborah's great to work with. Always a pleasure. So anyway, that's it in a nutshell.
Thank you. And Stephanie, as part of our panel?
Oh, I'm part of the panel.
Yeah, you're part of the panel.
Okay, well, many years ago, I practiced at K&L Gates, and then I actually worked up for a startup nonprofit that became a social enterprise and impact investor. So I'm particularly interested in the triple or double bottom line companies that have social and environmental missions in addition to a for-profit mission. So that's my background.
Thank you. Folks, we'll talk a little bit, but you should feel free to interrupt, ask questions. This is very, there's no PowerPoint. This is a free-flowing discussion, so you should feel absolutely free to jump in with questions at any time. Don't wait, and put your hand up. So let me start with just maybe a generic question, which is, when folks come to you and you see these, a few founders come to your office and say, I want to start a company. What's the, we call it the biggest mistake, but let me do it this way. What's the biggest hurdle you see in front of them that you want to, the biggest question you have for them that's almost a go, no go question for them? And so let me ask you in the first case, David.
So interestingly, Dave, because there's lawyers mostly on or almost entirely on this panel. Well, one of the go, no go decisions is actually, do they have a team that can pull off the growth of an early stage company? Because it's really hard. There's a lot of work that goes into it. And the work that we do, we try to anticipate the kind of issues they're going to run into. You can't protect against everything with contracts, as everyone here knows. We could write a contract that's 1,000 pages long, and the first issue that's going to come up is what we would have addressed had we made it 1,001 pages. So we can do as much as we can to protect by contract, but is the team, can they work together? Are they capable of doing all the hard work, the 24/7 that goes into a startup? And are they aligned on what that's going to take? And do they have mutual goals? And are they prepared to be flexible and coachable? And that's not easy to divine in that first meeting, but you begin to get a sense of it. And in the kind of conversation that we have, we try to guide them to understanding and facing those issues. And can they do it properly? Because if they can, then we can get them going. We can set them up and we can put all the contracts in place. So I don't know if it's really a go, no go, David, but you can sense, and I'm sure everyone on this call has, when something is going to be really hard to pull off. And you got to be of one mind.
Yeah, it's interesting. Part of the process of putting the company together, you see the interaction between them and the way they deal with each other, and what are really hard discussions, right? About what happens if somebody leaves and all that stuff that we'll talk about a little bit more. But you see that interaction that comes out, right? In that relationship. FJ.
Well, I'll comment because I agree with everything David you just said. I come at it from a slightly different perspective because I find that, I obviously try to give my clients and potential clients the best advice I can. And I may see that they're not working well together, but I don't necessarily, I don't necessarily view it as my job to decide whether or not they're going to make it. I mean, if they want to form the company, and I'll give them all the advice they should get, but I guess I don't view myself as telling them, no, I'm not sure how you'd say, no, you don't want to do this. I mean, if they want to do it, I may say, look, you're not I don't think you're approaching this the right way. And we can get into a specific example of that when we get to vesting of equity and discussions about that, which to me is one of the worst mistakes people can make when they don't vest equity. But, I try to give them the best advice, but then I look at it as they make their decisions. And if they want to go forward with the company, I may have a good idea that company's not going to get there, but I don't view it as my job to say, you know what, your company's not going to make it. And I don't think they want to hear that from me, even if I'm right. So anyway, I don't know. So I don't disagree with you say, but it's a slightly different perspective, right, where I see it.
And after, let me just say, I would never say to someone, don't start this company.
No, I know you would.
Yeah, but it's like, what makes the hair stand up on the back of my neck, right? Where I can walk down the hall afterwards and say to one of my partners in my group, this is going to be a tough one.
Well, there's also, I mean, if we're giving folks here advice on what we've seen mistakes they make, I think what I hear you saying is that, I mean, obviously we're not going to tell them that they're not the right people for each other, or they're not motivated. But when they're looking around, they're choosing the people with whom they're going to start a business. One of the things I think I hear you saying is they ought to think really hard about who it is, look really hard, make sure that they're aligned, make sure they have a good working relationship, and they're equally committed to the process. And when they're putting this team together, they ought to think hard about that. I don't think anybody's saying that we as lawyers are going to say, yeah, you're the wrong, but we might, I think what we're suggesting is that they look really hard at each other and take that into account when they're dedicating themselves. There's lots of opportunity cost, and so so they need to think really hard about that when they embark upon this. One similar thing to yours and I'll get others in here is I agree with that. I also I really like to hear people think hard about the business and whether and again, this is not a lawyer thing, but one of the things I like to ask people is, what are you going to sell to whom for how much and make money at it? because a lot of people have they fall in love with the technology, and they should. They're passionate about the technology, but that's very different than starting a business. And so, I certainly understand and have seen very successful companies change, many times along the way and more. But it's good to begin thinking really hard about how are you going to commercialize? How are you going to make money at this? Is there a real business as opposed to an idea or a technology? And so that's one of the things that sort of I like to ask people to make, because there is a difference, and folks often don't think about that, at least in the first instance. Deborah, people coming into your place, thoughts, or you're on mute.
I'm in a different position because my client is innovation work. So I don't have startup companies that are clients. And so kind of in this kind of these early days, I'm usually not involved. There are kind of other members of our team, non-lawyers, who are kind of assessing the business and assessing the team, but I don't really come on board until later.
Yeah. All right, let me go to FJ. You went down a different path here for a moment, talking about the vesting. So they're in your office, and now they're going to put this together. And you said earlier that you had strong feelings about vesting.
Yes, I do. And so, I mean, probably the biggest mistake, if I just had to pick one that I've seen in companies, is that the founders did not, that you have several founders, and they did not vest their equity at founding or shortly, at founding typically, or shortly after founding. And you end up with founders who have large stakes in the company, and one of them leaves, and they leave with the equity. I mean, to me, I've seen that, kill companies or almost kill companies, or have companies bending backward to try to figure out ways to solve those problems, and they continue just be continual problems. So I just think that equity arrangements and not vesting it, not making sure that if that founder leaves, so I'm sure everybody in this call knows what I mean by vesting, but just, if somebody leaves, they can't walk away with all their equity. They have to earn it over time. They get it up front, but it can be forfeited back to the company if they don't stay for a certain amount of time, or, and investing over, now I'm seeing it used to be a little, I'm seeing more just, 1 year cliff, and then, the 3 years after that on a monthly basis, which is pretty standard. But I used to see more, I don't know about you, the rest of the folks on this call, I used to see more variety and more sort of attempts to be creative. And I guess I'm seeing more of just everybody seems to be moving towards that direction. That's just been my experience. It's been more uniform recently. And I think maybe it's because of the types of funders that are just asking for that and expecting that. I'm not sure. But anyway, failure to properly vest equity is a huge mistake in my mind.
Mm-hmm.
I would like to sort of pile on with that, Dave, because I'm with FJ completely. When people come and they've had no provisions for vesting, that is a recipe for disaster. Because if you're in the situation I gave, when people aren't really suited for one another, they don't have common goals. If someone leaves and takes half the company with them, that's almost impossible to overcome. But you can have the same problem even if it's not quite as large an amount. If it's 15% or 20%, that is still a lot of dead equity on the cap table. And when investors come in and they look at the cap table and they want to make sure that the people who are there and running the company are adequately incentivized or motivated, and they see a big chunk of the company held by someone who's no longer there, that gives them pause. And sometimes that has to be addressed. And I've had issues recently with people who had spent a fair amount of time before actually forming the company, working on it and thinking it through, and feeling like they knew each other really well. and that they would get along great and they would be a great team. And they did a much shorter vesting that kind of accelerated the vesting. Maybe they had 25% up front when they formed and had the rest of it vest over 2 years. And then they found out after a year that one guy in particular, who was the CEO, was a disaster. And he had to exit the company, and he took a fair amount with him. Now, fortunately, we had built in provisions to repurchase the vested equity, right?
Yep.
Not just to give up the unvested, but to repurchase the vested equity and to repurchase it with a promissory note over 7 years. So it wouldn't be as big a cash hit to the company, but they still have to pay for it. And you still have to usually have a negotiation over value, despite whatever the documents might say. But they managed to get out of that okay. But they really got into the initial problem by having too much equity vested too quickly before they really got a chance to see how they all performed in this company.
I think that's worth emphasizing, because I think that's that last point that you made, David, is one that I say I have the most trouble with clients getting them to agree to put it in the first place, and it's the one they're most appreciative for later, which is the right to purchase vested stock when people leave over time at the then fair market value. On the theory, and let me just expound on that just a smidgen more, on a theory that folks should be entitled to the benefit of the value of the property, of the stock from the time they come in to the time they leave, and they should get that for vested stock, no question. But what they shouldn't have is the value after they leave till in perpetuity. They shouldn't have these little lottery tickets. And I want to take that value and provide that to somebody else. And that frees up that stock for somebody else, for other people, and frees up the cap charge. That is, as I say, that is, now it doesn't have to be all or nothing. So sometimes you negotiate some percentage of what they had. They call it 50%, 75% or something, so they can continue to have something. But to be able to have that repurchase right is actually kind of important. So I just want to layer on top of that. I think that's a really good point, and it's useful.
Deborah, I know that Deborah, we've had companies that have come to Alpha Lab and they've already been formed, they're already operating, and they don't have any vesting in place. My recollection is that Alpha Lab says, hey, you've got to put vesting in place if you're going to get our dollars. Is that still the case? Is that still what you're requiring?
Yes, and that is the result of a very bad experience in one of our very first cohorts. I can't remember if it was the first or the second, but it was a team of 4 individuals, and like within a month of starting the program, one of the founders got his dream job in far away. Yeah. There were no vesting provisions in place, and they spent the rest of months negotiating the terms of his departure, and they did ultimately reduce his shares, but it was, instead of just reverting to the kind of agreed upon vesting provision, they spent months and legal fees trying to work things out. And so after that, we required vesting, and we still do.
Perfect. Yep. Okay. All right. Anything else on vesting?
I just have a
question. I have a question for the two Davids. Are vesting provisions typically in the founders' agreements, or do you see that as a separate?
There, as a logistical matter, there's often a restricted stock agreement that they sign that's separate and apart from the original, that called the stockholders agreement. So it's typically they sign a restricted stock agreement that provides for the vesting, typically.
And they file an 83B election. And as we talk about mistakes, the mistakes that you see are when people don't file the 83B election, even though the law firm is hammering on them and saying, here's this, you got to sign it, you have to file it within 30 days with the IRS, and they don't do it. Or we say, send it back to us, and they get it back to us, and we do it. But if you don't, if you get that stock up front for, you know, 1/1000th of a cent a share, the founder stock, and you don't file the 83B election, then every time you have a vesting event, you are technically, actually, you are taxable on the fair market value of the vested shares at that time, which is a terrible result. And we have to go back and go through all kinds of gyrations to try to fix it. So that's another mistake that people make. Now, when new investors come in down the road and say, hey, we want you guys to, or gals, to revest in some of your shares, that's a different issue, and that's a negotiation you have with your investors. And so sometimes, Dawn, the vesting does come later. I would like to throw one other thing out, Dave, about vesting. Everything we've talked about is time vesting. You know, 25% cliff means after 1 year, you get 25% vested, and then it's monthly, quarterly, annually for the remainder of it. But some clients want to put in performance vesting, where you have to achieve a certain goal to get vested in your shares. And that's wonderful if you know exactly what that goal is going to be, and that goal isn't going to change in the next 6 months or 9 months. But we all know that companies change dramatically. They pivot to meet the market demand and other things. And if you have performance vesting, it may be that the performance you wanted to see really isn't relevant anymore. So it can be a problem, but if it's done correctly, it can work well.
Yeah, like you, I sort of tend to try to dissuade clients from performance vesting in the early stages, because the future is not known. If you get further down with a more developed business plan, and so you hire, as an example, you know, a salesperson or sales marketing, and so you're doing it based upon sales or something like that, then one can get there, or perhaps a CEO based upon certain milestones. But it's hard, and so to figure it out, at least in my experience. But the 83B, what he said, just, you know, it's absolutely essential, and it's a difficult problem to solve. It's interesting, you know, as you go through the funding cycles. I don't know, Deborah, if you do this, but I mean, others, investors, when they all want to see the evidence of the 83B that has been filed. So they're not going to. So people are not going to have this tax. I mean, nobody wants to have this tax issue down the road. So we do that. All right, that issue. And by the way, the vesting. So the vesting that goes not just for founders. I mean, the same issue is for in the employee options, employee equity as well. I mean, the same. You know, what we just talked about is mostly for founders, but it's very analogous and almost the same for employees, which is you want employees to have vesting. You don't want to have their options or restricted stock, as the case may be, up front. You want if they give them restricted stock, you have the Kalson 83B issue that you got to address within the 30 days. And we also build in the repurchase rights that I just described for the vested stock. So employees, it's a very similar kind of arrangement.
Dave, we run into, here's mistakes we run into with options, and I know everyone on the panel has seen it. You tell someone you're going to give them options. You even write it into their consulting agreement, but you don't do it. You wait, and you wait, and you wait. And when you finally grant the option, the value of the company has gone up dramatically. And the exercise price for the option can't be less than fair market value, or you have a parade of bad tax consequences. And people want to go back and say, well, can we just date the option for when you said you were going to give it to me? Because I'd like to have that much lower strike price. And we can't do it. We can kind of make up for the vesting. We can give people additional vesting up front, but you can't go back a year ago and say, well, this is the strike price. This is the exercise price for your option. So that's a problem too.
Well, I've actually seen it even not just with options, but I've seen it with founders. amazingly, which is, I've had, people come and say, okay, you have 4 or 5 founders, but they only wanted to issue stock to one of the founders for some reason I couldn't fathom. And they didn't want to grant the equity to the other founders. That, well, we'll get to that later. And you try to explain, no, you do not. That is a huge mistake. And, sometimes they take your advice and sometimes they don't. I mean, it's so, and then you're trying to figure out later, well, okay, now that they're ready to issue equity to all the founders and the world has changed or their company has changed, how do you deal with that?
Yeah, exactly.
I
All
have
right.
another vesting related mistake. David, you had mentioned about introducing the option for the company to repurchase. And so the company needs to be careful that it observes whatever requirements are associated with the repurchase, like timing, notice, etc. Or in many cases, the company can lose those rights.
Yeah, that's a great point. It's a broader point, which is that the deadlines, people just need to pay attention to them. And so, for example, most of the ones I do with the repurchase right for just, I don't know why, because I went this years ago, but it's exercisable within 180 days. I don't know why, but that's a magic number I have in it. And it's got to keep track of it, right? I mean, it's got to be done within that period. But, one lesson, just a broader lesson here is to, so many times people miss deadlines. I mean, they miss rights. And having just a system to keep track of these dates is so important. And I don't care if it's just a broader point of contract rights, of renewal rights, contract rights, termination rights, dates that you have to that, the 83Bs, it's just important for startups to have some mechanism to keep track of these dates. And I've seen them waive rights. That's a good point. Yeah. Cool. As long as we're on employees, any mistakes you've seen on the employee side? Maybe none. Maybe
Well, no. I mean, employees are. I've been trying to think how do we narrow this down? I think whether it's an employee, but even more so with a consultant, Dave, is not having the proper agreement where the consultant assigns to the company all of the IP that they're creating for the company. This is really critical. The company has to be able to say to investors, to acquirers, we own everything we say we own. And a lot of times, not a lot of times, but occasionally I've seen companies come to us and say, well, they signed an NDA. And I said, well, that's good that they signed an NDA. But an NDA doesn't, unless it's a really unusual NDA, non-disclosure agreement, doesn't address ownership of IP. And you need to get them to assign their IP. And that's real easy to do when you sign the consulting agreement or when they sign on to their employment agreement. But if you wait, and then the company becomes really valuable, and now you have to go back and get them to assign it, they may say, well, what's in it for me? And oh boy, we got trouble now.
So it's interesting, even on the, that's so, thank you, essential. And it's interesting with founders, what I've seen is people confuse the IP on the date of contribution of formation. So it says, well, I did assign my IP. It's in my, when I subscribed for the shares, I assigned all my IP, and therefore that's all I need. And we ran into this recently with because there was 2 parts. One is the contribution then, and 2 is the consulting arrangement going forward. So everything you do as a founder for the company going forward is assigned to the company. These folks only did part 1, didn't do part 2, and it was an issue. I mean, because some of the founders no longer were as intrigued with the company as they might have been, and they actually didn't want to. And it was a huge issue for this company. So, so you're absolutely right. It's essential for the company's growth that the IP be assigned. And just one more note, it's essential that they be assigned currently, right? I mean, just one, it can't be, I will assign, It can't be an agreement to assign later. It has to be a current assignment of the IP. I hereby assign the IP to the company. And just to be clear, as a consultant, if they don't do it, it's not, it's the most, putting employees aside, which, one cannot maybe argue. Consultant, they haven't. If you don't have it in the consultant agreement, they haven't assigned it. You don't own it. You paid them and you don't own the IP. But to David's point, it's a more practical issue, which is you're going to have real trouble with the financing or sale because you can't show them that you own the IP.
Right. I mean, the company has a right to use it, but that's
Right.
not the same as owning it, because it means
Right.
the consultant can take that valuable IP and they can start their own company with it, or they can sell it to someone else, or they can do whatever they want with it. And you really, that's sort of you don't want that, and we just see it all too often.
On the let's hang with employees and IP. I do think it's important. One of the things that when they employees and founders, it's funny how often you ask questions and say, well, what obligations do you have to third parties? And they'll say none. I own it. Okay, cool. That's nice. Then you don't stop there. Say, okay, well, all right, cool. By the way, you're working somewhere else, right? Yeah. What's because then I'm going to do this. Okay, cool. So what does the IP assignment say for your current employer? Well, I haven't looked. Okay. So the point is that you want to look around and make sure that there's no third parties who have any rights in the IP, or frankly that you're subject to any non-compete. But and I have had this issue, which is that they have not looked at it, and it turns out that the current employer has a claim on some of the IP that they now think they're assigning to the company, and that's not perfect. Not even close.
David, your
okay.
comment made me think of this isn't just employees, but the comments everybody's been making are good, and I think one of the big mistakes that startups make is they don't recognize how complicated this usually is, and certainly can be, and almost always is. I mean, the levels of detail to get to all of what we've just discussed, and to sit down with a client, particularly one who has not done a startup before, and try to explain to them why all of these things are important and why you need to be spending so much time talking to me about these different issues, when they don't usually want to spend that much time talking. They just want to hear, okay, the company's formed and we can just go and do what we need to do. But there's a lack of appreciating the nature, the level of detail, the complicated nature of what's going on, and just making sure we have all these things nailed down. I think that's a common mistake.
Yeah, I agree. So what do you do? I mean, so I'll pause it out. I had a client one time that got pretty far down the road in 2 rounds of financing. It was all good. But then they realized that they were infringing somebody else's patent. And that led to some sleepless nights for everybody. But they managed to do a workaround and get around it. But the problem is that, but the question is, what are you advising your clients in connection with to avoid that problem? Because that's a bad day. If you realize that you're infringing somebody else's patent.
Well, I'm telling you, I have an IP lawyer as well. I mean, so, I think David and, and I are corporate lawyers, we probably refer to ourselves as, who do a lot of work with intellectual property, but I'm not a patent lawyer. I wouldn't call myself an intellectual property lawyer. And particularly when, for instance, a company will license a technology from a university, Pitt or CMU, most frequently in my practice, and they will think that the lawyer who represents the university and is prosecuting that patent application on the university's behalf is also their intellectual property lawyer. Now, there's a variety of reasons why that's not the variety of reasons why they need to understand that's not the case, but they need someone who's looking out for their intellectual property needs on their own. So if it's particularly if it's a patent driven technology, they really need to have their own IP lawyer. So, and it's not that those of us on this call who aren't IP lawyers per se can't help with that. I'm sure we all do, but just understanding that you really need to be thinking about your IP, because most of the companies we're talking about are IP driven, a lot often patent driven, well, not always, of course, but you just need to be thinking about that from the earliest stages.
Can I ask a question on that? That if I'm the company, I'm licensing IP from CMU into my company, does CMU give any warranties or guarantees that it's
No.
that?
No,
No,
no
that's a big
universities
fat
do.
no.
Come on,
Nope.
David, you can work on that one, David Lehman.
Yeah, really. I've tried. No, and to the point where FJ and I had a situation once where there was an issue, where there was the university arguably had issued sort of right of first refusal to a third party beforehand, and nobody knew about it, and so it can happen, and so and the university wasn't standing behind it. So they don't make any representations or warranties, and it's incumbent on you to ask questions and do the due diligence associated with it. And the good news is, let me just make one comment, I'll shut up. The good news is that most of the time, or often in our world, the professors that we're dealing with are actively involved in the technology, and usually know if there's some issue, which is to say through the funding or it was funded in a certain way, or there was a license. They typically would know, and so the risk isn't very high because they would typically know that the university would have done it because of their technology generally. Okay, sorry, I interrupted you.
No, I think this is a tough issue because some of this is economics. If we're going to be filing a patent for someone, we're going to do a patent search. That's not terribly comprehensive, but it's enough to know whether there's something out there that squarely is going to prevent you from getting a patent. And we've seen that. We've had clients who've come to us and they have a brilliant idea. The trouble was someone else had that brilliant idea a year ago. And at least at least they found out about it before they sank any more money into it. The disappointment was huge, but they could get on with their lives. The thing is that to really know whether you're infringing, you may need to do a freedom to operate search. And that is really expensive. I mean, that can be, 10 times the legal fees that you pay to get your company up and running. And most early stage companies that I've worked with don't have the funds to do a freedom to operate search. So even if you've been diligent about looking at the existing patents and filing something, you don't know for sure until down the road, as David said, where there's an infringement. Now, if you're working in the life science community, there's infringements that are going on left and right. And there's sort of an understanding that if you're building a life science company, you're probably going to have to in-license certain technologies. And so I think maybe that's a little bit less of an issue, depending on what industry you're in. But in others, you could be squarely out of luck. And then, as you said, David, spend $500,000 on a workaround, but maybe you can do it. And one of our clients did exactly that when they got hit with an infringement suit. They spent a lot of time and effort negotiating with that company to come up with a kind of a stopgap measure. And then they engineered like hell to get around it. And they did it.
But
I
I
have a
will
question.
say, good.
I have a question. In terms of the restricted stock agreement investing, that would be an element of a founder's agreement, or it's a separate entity. What would be the other elements in a founder's agreement that you would recommend? What are the boxes that should be checked in every founder's agreement?
FJ, you want to grab that?
Yeah, sure. I mean, I'd say the biggest one practically ends up being because some of these agreements end up getting, when you take funding from a VC or other professional funder, these agreements end up getting rewritten. I mean, and now, I mean, even every deal that I do now with anybody who's not just even a VC, but like angels who want to sort of view themselves as VCs, and or just anybody, they're pushing for the NVCA, National Venture Capital Association forms. And I mean, you know, so all the deals now I do are just those, that's that form. So I guess what I'm saying, I'm not answering your question, Don, but what I'm saying is these agreements end up getting rewritten because then everybody's using the NVCA forms, but that's down the road. That's not a startup. So it's startup, the biggest ones, or the ones that a drag along right, so that if you want to sell the company, you have the and a majority of the company wants to sell, majority of the shares want to sell, you can drag along the rest of the shares. Also a lockup agreement if the company is going to, go public. You want, and I know that's a long way down the road, but I'm telling you the things that I think that the investors want to know that are already in there, because they want to see they want to see some of those things, even if practically speaking, it's going to be a long time. And then, a right of first refusal with respect to sales of stock by the founders or others in the company early on. If they want to sell, they've got to offer it back to the company first. Perhaps they have to offer it to some of the significant shareholders in the company. Those are the things that I would, most want to see in there typically.
So
And I want to make, Don, I want to make sure we're talking
about.
Want to make sure we're talking about the same thing. Because you can
Well, let me tell a story that you lawyers can pick apart. There was a company actually came through Project Olympus. It was a company came up with a really clever idea that helped fulfillment in grocery stores, which is very backwards. Great opportunity for improvement. These guys came up with a really clever solution. There were two co-founders. I think they were equal in stock. One was designated CEO, the other was a chief operating officer. The chief operating officer did all the work. He got a pilot agreement with a major grocery store chain. Meanwhile, the CEO got a real job and was getting salary. They had a dispute over pricing strategy to offer this groceries chain, and they couldn't agree. And the COO wanted to buy out the other guy. He said, "Yeah, you can buy me out for $200,000." Of course, this company had no money, so it was unrealistic. So they literally spent a year in court, and I don't know how much money was spent on litigation. But meanwhile, there was tremendous opportunity lost. They lost the big pilot opportunity, and I didn't even know if the company's around. But it was over dispute resolution. I mean, it was a combination of that plus vesting, because it was, just not.
Don, I think I know the company you're talking about, and they never had they did not have it in writing. So what they only had was email about what the percentage that they were going to split it 50-50. Because I ended up actually going to court to test.
Well, so let's just start the basics, right? 50-50. Let's start there. I mean, that is a road to disaster and a question of, okay, what do you do with that deadlock? And if you don't think through what you're going to do if there's a deadlock with a 50-50, then shame on you. And and it's not perfect, right? There's solutions. There's the shotgun solution. There's or whatever phrase you want to use for a divorce mechanism. There's don't do 50-50. Create a 3-member board and appoint somebody as a board member. Have an arbitration to have a third party, an arbitration thing. I mean, there's mechanisms to solve it, and a whole myriad of them, which all of us have used and implemented and done. But the point is, thou shalt have some kind of arrangement if you're going to do a 50-50.
But that would typically be in a founder's agreement.
Yes.
So, Don, this is what I was going to ask before. That there's a founder's agreement, as I think of it, is just an agreement when people are thinking about starting a company and they're working on this project and they know they're going to make it happen. And you don't want one of them changing his or her mind and then going off and doing it themselves. So they agree that whatever they create is going to go into this new company they're forming. They may agree, hopefully, on what the equity split's going to be, having given it some thought. They're going to agree that the agreements will have these vesting provisions. So we lay out the main terms of it. It can be 6 or 7 pages. So you have some comfort level going into forming the company. When you go in and form the company, there's not necessarily a founder's agreement per se. There's a restricted stock agreement. There's a non-disclosure invention of assignment agreement. There's a stockholder agreement. And all these agreements taken together create all these rights and obligations and hopefully address the issues that we talked about before on vesting. So for example, the guy who goes to take his dream job doesn't take all his equity with him, and maybe it has a provision to buy him out over a long period of time. So you say it's $200,000, fine, I'll pay it over 7 years, right? I don't have to take $200,000 right now. So that's exactly the
But if
kind
they
of
had
thing-
agreed upon that up front, it would have been, a 5-minute conversation versus a year in court.
Well,
Yeah.
maybe 5 hours, but you
Yeah.
could still get to it. And that's again where people find out whether they really should be forming a company or not. Because if they can't agree on this stuff, they shouldn't be doing it.
Yeah.
So just to be, so they're in, the terminology is just to be aware of. I mean, people use some of this terminology in different ways, and generally what David described with founders agreement and the other agreements, the way I talk about it. But some people call founders agreements, or they'll refer to them as buy-sell agreements as well, where the founders have an agreement like that to deal with one party wants to buy the other one out, or there's a deadlock or something like that. Which, so it's just understanding what the terminology is and how somebody's using it is also important. But if you don't have a 50-50 and you do the other things David has mentioned, then you probably don't, you may not need that buy sell per se, because you've already got other provisions in there too.
So you would typically, so I mean, in the founders agreement that you're referring to I think about it sort of, the reason I was out is, I think of that as a stockholder agreement, essentially, in the, once you form it in the corporate form, and an operating agreement in the LLC form. That's sort of where a lot of that would be housed together with the restricted stock agreement. So basically, before or after.
I have to jump out for another meeting. Thank you
Okay.
all. Good to
It's our
see
pleasure.
you.
Good to see you. Thanks for joining us.
Bye-bye.
So I will just add that team that Don and I were referring to, they were best friends in high school. So this was thinking that they just trusted each other. We didn't need to do this. And I would bring it up like every other time when we met and said, and then he obviously paid the price on it. So.
And I have a best friends in high school client, 50-50. The equity split should have been 95-5. The one friend had everything, knew everything about the industry. The other one knew something about being a graphic artist, which they could have paid for a couple $1,000s. It led to the most nightmarish company journey I've ever been on, and it's still not over. And this started 5 years ago. 50-50, best friends, makes me shudder.
Hey, as a member of a startup that made many mistakes that Dave Lehman knows about for a nonprofit, so much of the conversation in our startup nonprofit was trying to get the founder to realize that he was not the client, that the client was the entity. And how do you have that conversation early on? And if it probably continues in the nonprofit world, they call it founder syndrome, to get them to understand that it is the entity that is not the client, and it is not the individual who may be the only founder, but even in that case, he's still not the client.
So let me give you the joke about it. I mean, the funny is the latest moment they will actually learn it is when we're sitting in the boardroom with the VCs firing them.
Yes.
That's the moment when they realize, hey, wait, he actually doesn't represent me individually. But if they haven't gotten it before then. But all joking aside, that's and Dave Kalson knows what I'm talking about. Because I remember years ago, I think you ended up representing individuals on that one. But
Yes.
putting that aside, it is essential that very early on, at the first meeting, people and the clients understand, the founders, that the lawyer represents the entity and not the individuals. And I half jokingly say to people, I have the benefit of my client not being in the rooms, you know. But it's essential that come out very early. The privilege goes to the entity, not the individuals. And so what they tell, you know, and people are surprised by this, even later stage companies, right? When we sell a company and the CEO realizes that those emails that he shouldn't have sent me and now go, you know, are now the proud owner of the company, and the new buyers get them. You know, the privilege goes with the entity, the entity is the client, and that's kind of awkward, but they need to understand it. And so, and as an example, to the vest, to go back to the vesting thing, you know, the individual, none of the individuals, that's not their best interest to vest the stock, arguably, other than to protect their stock if the other one leaves. But it's a company. It's the company's best interest that the stock vest. So that's an early discussion. And somewhere along the line, you have to say to the shareholders, your interests are diverged enough that you really need to get your own lawyer at this moment. It's time. And I happen to, and there may be different views on this subject. I actually think it's important to do that. And it's part of our job as company counsel to do that. And so some people are sort of reluctant, and they say, well, you know, I don't like to send people to lawyers. And no, I think it's part of the job. And actually the whole thing works better if you, at the right time and the appropriate time, say, no, you really need a lawyer at that point.
So
I would just like to weigh in and say, not any lawyer, because the thing that makes me like talk about the hair on the back of your neck, when it's usually through an accelerator company, and then I'll say, have you been working with an attorney? And they'll say, oh, my uncle has been helping us, or my father. And unless that person like has experience representing startup technology companies, it is guaranteed that things have been done improperly. So just my 2 cents.
Well, that's fair. That's fair. Yeah.
So as I always say, you don't want to hire an orthopedic surgeon to do your brain surgery. You really need to have somebody who knows what an 83B election is. That's my sniff test. I always ask them, do you do 83B filings? And then they look at me. Oh, so they're not startup model.
Yep. All right. Maybe to turn gears, I know we're going to not have that much more time. Let's talk about we talked about vesting, we talked about employees, we talked about some IP. What about corporate formation? What's the biggest mistakes you've seen in the corporate formation side of it? David, you want to take that?
Well, you know, sometimes it's a real mistake. And sometimes it's just a matter of judgment. Did you make an informed judgment about how to form your company, knowing what the likely path is to funding and exit? So like the real mistake we see is when someone forms an LLC, a limited liability company, which is a partnership for tax purposes, and their accountant says, hey, you should make an S election to be treated as an S corporation so that you can pay W-2 wages and you can deduct them. And they say, hey, great, let's make an S election. Well, an S corporation is not a vehicle for raising money. It's not the right vehicle for a technology company. For a service company, it's fine, but you can't have entity investors, except for maybe a 501c3 like Alpha Lab. So you can't really ever hope to raise money through an S corporation, and converting from an S corporation to a C corporation can be fantastically expensive. So that's an out and out mistake, flat out. The judgment errors may come in, did you form as an LLC or did you form as a C corporation? And maybe forming as an LLC until you understand what your business model isn't a bad idea. Maybe you'll end up as a licensing company and it's more efficient for tax purposes to just flow through all those royalties and milestone payments right to the owners. But for a lot of companies, they're going to need to raise several rounds of venture capital from investors who want to invest in C corporations. And if you know that, then you're probably better off forming a C corporation right out of the gate and might make your life a lot easier. So, this is the kind of thing you really need to talk to your counsel to your accountants, your financial advisors, and really understand what direction is this company going to take and what makes the most sense in how we form it.
Well, and a mistake I've seen, plug for lawyers here, but is when they form the company without a lawyer. And which is fine in some situations, you can form a company without a lawyer, but if you're doing a technology startup, technology-driven startup, it's probably not a good idea. It's not the end of the world, but they've made decisions and made not knowing what. I mean, I had one client who they formed a Pennsylvania non-stock corporation, and I asked them, well, why did you form a non-stock corporation? And I don't remember what their answer was, but I guess it seemed like a good idea at the time. And so then I had to do a little bit of research on how do you transition from a non-stock corporation to a for-stock corporation, or you just start a new company, or what do you do? But anyway, I mean, those are the kinds of mistakes that sometimes people make just because they've never done it before and they didn't work with a lawyer to at least get started, so.
I would say one other mistake that I've seen in the social enterprise situation is to have founders come in and say, I want to be a nonprofit. We have a social mission, so I want to be a nonprofit, without any understanding of all of the complexities that come along with that decision. So Kit and I both have sort of advised students who come in with that. It's like, no. You can have a social mission without becoming a nonprofit. And so let's not make that decision early on, because that's a decision that can never be undone.
Oh, absolutely. Yep. Yeah, that comes with all kinds of constraints and problems. Got it. And obviously, if you're going to make a mistake, it's better to make a mistake by starting as an LLC, because you can convert to a C corp relatively easy. Although it's not as frictionless as we'd like to make it out to be, but it's at least from a tax perspective, it's doable. From a C corp to an LLC is not doable from a tax perspective. But it's not as frictionless as I think we sometimes lead people to believe.
Many years ago, David, we did transform a C corp to an LLC once the owners realized that it was a cash cow and they didn't need to reinvest in the company, and they just wanted to throw out distributions to the owners. And we figured out a way to do it. It was very complicated,
right?
And we did do it, but it would have been a lot easier if they had started off life as an LLC. So it's not always right to say, we'll just become a C corp.
Correct. Yep, I agree. Cool. I'm Deborah, I've forgotten. The Innovation Works doesn't have a requirement either way, right? So they're agnostic.
We're agnostic.
Versus
We're agnostic.
Okay.
And CMU is agnostic, but Pitt really only wants to license the C corps. So if you're spinning out a technology from the University of Pittsburgh, you're pretty much going to have to be a C corp. At least that's been my experience.
Yeah, although I know LifeX will fund LLCs. and to work with LLCs.
Yeah, Blue Tree used to do LLCs, but now that they've converted to the VC, they are just doing, they will not do LLCs. They will only invest in C Corp.
I think people need to understand that one of the issues is that these big venture funds that come in down the road have partners, tax exempt or pension funds and foreign partners who there are negative tax consequences to investing in an LLC. And so you have to basically become a C Corp, right? You have to convert
Right.
from an LLC to a C Corp to get their investment. Certainly doable, but can be a lot of work involved. And the longer the company's been around, the more expensive that is.
So this is not necessarily legal, but I will just say something that one of my startups almost made the mistake of is that obviously looking for funding, you found somebody that a VC that was going to invest in them, and what they were going to require that some of the money that was given to the company would have to be paid back to the VC for the services that the VC was going to do. And it's like, this is a little weird. Why don't you do a little more due diligence on the VC? Because everybody gets excited because somebody wants to fund me. And what he ended up doing is calling some of the portfolio companies. After he asked the VC, can I talk to some of your portfolio? And they said, no, we just don't do that. But they were posted on their website. So he went and started calling, and the first two said, I can't talk to you, I'll get in trouble. And then the third one that he got was the CEO says, I'm leaving next week. I'm going to another job. Says, don't take their money. They're horrible.
Well, yeah. So doing due diligence on the funder is huge and really important, and maybe it's good to pivot to that. But let me give you one other war story that I ran up against about a year ago, and it was in 3 situations, and we managed to get them out beforehand. But I was fortunate enough to email people around my firm that there are some folks that are offering money to folks. It looks very legitimate, but it's not. And what they're dressing themselves up as VCs, and it's actually foreign potential foreign investors. It's a scam, and they look like they're going to do due diligence, and they do the whole thing, and suddenly you see that there's a fee associated with something. In the one case, it's a fee for basically some kind of a fee for the funds to arrive in the bank. So they make themselves out to be a banking fee associated with it. There's another one with an underwriting fee, but there's this fee that they want associated with this money. And when you pay the fee, then you'll get your funds. And this is there's a whole series of these scams going on. That we really need to be careful of, because it looks amazingly legitimate. And I had 3 potential folks almost fall for this stuff. So that's just something to be beware of.
David, I want to throw in another thing that I'm seeing a lot of, I know all of us are, is when companies are raising money, they'll look everywhere. And they will meet people who say, I can introduce you to money. And you just need to pay me a percentage of what I raise, 2%, 5%, 8%, whatever it is. And you think that's great. I'll happily pay that percentage. There's only one problem. They're not a registered broker dealer. And if they're not a registered broker dealer, then you fundamentally lose your securities exemption. And the investors have a right to get their money back. They have a right of rescission. It is a terrible outcome to use an unregistered broker dealer. And when we were all, FJ, Dave, and I were all early in our careers, it was kind of okay to do that. There was this unwritten finder's fee exemption that people would rely on. It doesn't exist anymore. The SEC and the state securities commissions have come down on that. If you're going to raise money with an intermediary, you needs to be a registered broker dealer. And it's a real problem, and I see it all the time. And I assume you guys do too.
Absolutely. Yeah. It's an excellent point, Dave. And I mean, I think just general lack of understanding of the securities law. I mean, the one you raised is a big one, but just not even recognizing that, hey, there's something out there called a securities exemption that you need to have if you don't have registered shares, meaning publicly traded shares. So, and not understanding that happens, and not understanding that happens when you issue options to employees, you have to deal with that. I mean, I have a client who is he has a law degree. He also has an accounting degree, practiced more as an accountant, acting as sort of a CFO for a client of mine. Sophisticated guy, but when he wanted to issue options to people, and I'm like, okay, well, in what states are they? You know, we got to make sure we're complying with federal and state securities laws and having an exemption. In some states, it's very easy. In some states, it's not so easy. And he's like, oh, well, I've never done this before. You know, I was really surprised because he's a good client. He's smart. He understands things. He's knowledgeable. But I was surprised that he didn't know that, you know, yeah, the securities laws apply even to granting options and whatever kind of security, which is a broadly defined term. So that's a big mistake that I see.
Yeah, very much so. It's interesting because I've also seen recently a view, in part with law firms as well, saying I'm not going to file in states. I'm only going to file federal, and take the view that it's been federally preempted, which is sort of interesting. That's not been my approach, but there's people around that are doing that, and I actually think it's a mistake because you can't. I mean, I don't want to have that discussion with future investors or et cetera. We take the view that it was preempted, but it's interesting.
The states don't take that view.
Correct.
So you're playing a game, because I mean, on a few occasions where I filed Form Ds, and I've gotten calls about them, and I was always, if there was an issue, I was able to resolve it. It was a misunderstanding or whatever it was. But I mean, the states do notice. I mean, some of the states that you file a Form D in their state and they read it, and if they think did something in Arkansas, and they have a standard practice of calling you and asking you, and I forget the question they had. They wanted to know something about a specific question, which apparently they just do. I don't file much in Arkansas.
Really?
But my point is, if you don't file a Form D, then your argument is, well, they didn't know about it. They're not going to know about it. So, and I can claim federal preemption. But if somehow they find out about it, they will come down on you. That's been my,
Yes.
The question is, how do they find out about it? And the answer is whistleblowers.
Yeah.
That the story I told you about the high school friends, 50-50, got into this colossal argument, couldn't resolve it, used an unregistered broker dealer to raise money. When the one was out of the company, I'm almost positive, is the one who approached the Pennsylvania Securities Commission and said they used an unregistered broker dealer. And we spent several years. This happened, by the way, Dave, to your point, before we came in as counsel. But we spent several years having to deal with them, and the unregistered broker dealer is still dealing with it. So, I mean, regulators have a way of finding out when something has happened or not happened.
So let me pivot for raising capital, because we were still in there. So if you were to come up with the biggest mistake that people have made in raising capital, early stage, first round, what would the mistake be? I'll put you on the spot, Dave.
Boy, that
I'll do mine first, and you can do it.
okay.
Mine
Go
is
ahead.
Too much at too low a cap. Convertible debt with too much at too low a cap, and so you end up with giving up too much of your company without realizing you're doing it. And so, and convertible debt is, we always talk about it, is easy to go in, But today people push back on the cap, really hard on cap investors. And so you end up basically taking on too much money at too low a cap and giving up too much of your company early in the early stage. That's
Yeah,
my pet peeve.
I guess
That's
a
my pet peeve
corollary-
for today. Yes.
I mean, a corollary to that is the convertible debt overhang. Because convertible debt is, to be crude, is like crack cocaine because it's so easy to use versus having to go and negotiate a priced round, which is hard to do when a company is early and no one really knows what it's worth. And it's
Yep.
so much easier just to take this convertible debt. But if you've got $2 million of convertible debt, and now you're ready to raise a priced round to convert the debt, but it's only going to be 2 million itself, and you've got a big discount on the convertible debt, and you've got interest that's accrued, the investors, the new investor, the priced round investor, the sophisticated investor, is not even going to control that class of preferred stock
Yep.
After you close. So
Yep.
That's kind of another corollary to that. I agree with it.
Yep. FJ, anyone for your side? Put you on the spot.
Yeah, I mean, biggest mistakes. Well, one of the big ones is they do convertible debt and they set too short a maturity date on the debt.
Good point. Yep.
And I've had a number of clients, and even when they set a long one, like 5 years, which is what I usually push for, which is longer than some investors want to see, but typical for like, Innovation Works or something like that. I've just dealt with clients who are going back to investors and saying, you know what, we haven't converted yet, and I need to extend the term of the note, and we need to negotiate with them about that. And sometimes it's not that hard, sometimes it is. So,
well, on a that's good point. On a related matter, it's important, and I've seen people not do this, which is if you're issuing debt, make sure that it's in a series in which each, so basically a majority or something less than unanimous can amend the notes.
absolutely.
Because if you don't, you have to get everybody's approval, and that's the problem. So
Like
being able to
for-
amend, the world changes, and you got to be able to amend it without a unanimous approval. Like what's that?
You get 40 separate negotiations.
Correct.
And it's unlikely that all 40 negotiations are going to go well.
No, I just want to be number 40.
Yeah, I mean, to your point, David. David,
Yeah.
you and I are familiar with an LLC that had an operating agreement that neither of us drafted, that basically required 100% approval for a lot of, not everything, but most of the big important provisions, and then had like scores of members in the LLC, and it was just it was going to be impossible to get everybody to agree to amend
Yeah,
it,
no,
even if it made
yeah.
sense for everybody. It was just so you just had to work around it.
Yep.
It's
Yep.
So I just want to point out that some of these things are not legal issues. Some of these things are business experience. So this is, again, well worth it. So understanding the law, but understanding the business implications. So that's why having somebody who's done it over and over again is really important.
Let me see what time it is. Yep, 6:25.
Okay.
Let me but let me open up to the group. Any questions from other folks that have not asked questions or want to talk about anything? All right. Let me ask.
Quick question. Following up on your comment about converting one type of entity to a different type of entity. So I have a startup that I'm mentoring that are LLC currently, and they're thinking of converting to nonprofits. And based on this conversation, it sounds like it's not a good idea. Is that accurate?
Why? Why do
Why
they
do
want
they
to become a
want
nonprofit?
Oh, because they want to raise money, like do fundraising from corporations, not the same way the startups would do, but more like because they're currently getting funds from like grants type of funding. And so they think that nonprofit route will allow them more of that, like, government grants and so on.
Do they ever want to make money on this company? Do they have visions of one day achieving wealth through this company?
Well, they want to sustain themselves and grow as a company, not necessarily just in the business of raising money for the sake of raising money.
So what, go ahead, David, you want to finish?
No,
Move
no,
on?
go ahead, Dave, please,
Yeah,
step in,
So,
jump in.
what David's getting at is that if they want to make money, sort of from the the growth of the company to or otherwise, a nonprofit's the wrong vehicle, because I mean there's really no equity as equity. There's no way to sell it. That's not a money making venture. You can make money as you can be paid a reasonable salary. So if you start a nonprofit, you can be paid a reasonable compensation as a salary, but that's it. There's no upside to it. There's no shareholder increase. There's no investor. There's nothing like that. That's a different concept. So if you said if they want to grow it, if they're trying to grow it so that they can gain wealth, then that's probably not the right vehicle for them. Actually, it's not the right vehicle for them.
They can get government funding. They can get SBIRs in a for-profit, in a C corporation.
Right.
They may even be able to get certain types of foundation funding because there are new rules that have been created recently that do allow foundations to make investments in for-profit companies that they think are valuable. The R.K. Mellon Foundation is a great example of that.
Mm-hmm.
That's been making a lot of investments in early stage companies, but they will never achieve their purpose of building something that they can really profit from. So they need help. They really need to talk to a lawyer.
Yes, that's exactly what I suggested to them.
Good call.
But they're kind of thinking already, it made up their mind. Well, they haven't done anything, but I'll try to convey that. Maybe that's not a good idea. Thank you so much.
All right.
I have one quick question. We're just in the process of starting to take on investors. And so we actually have an investor coming over this evening, and they don't want a convertible note. All they want is straight equity. What is the thought on that? Why wouldn't they want a convertible note?
Well, from their perspective, they straight equity is perhaps nice. They now own their stock. They know the value of the stock. They've got their ownership at that point. There's no question about the value at some point as to what percentage they're going to get, et cetera. The question is going to be, what kind of stock are they going to get? Are they going to be getting common stock, preferred stock? What are the terms? What's the value? And most importantly, what's the valuation? What percentage of the company they're going to get with that stock? So when they ask for this, what they're doing is pricing the company, and they're going to take a percentage of the company in exchange for that investment. That's not necessarily a bad thing. It's just a different vehicle.
Lisa, I think the reason they want to do it is because they think the company has a low value now and it's going to become a lot more valuable. And they want all the upside that's going to come with buying in now at a low value. But that means they're going to get a bigger piece of the company for their money. If they get convertible debt or a safe investment, then they're going to convert at the first professional round when the value is much higher, with maybe a 20% discount. And they may look at that and say, well, that's not enough to reward me for my risk. So the way you handle that is with a cap. It's what David was talking about. We
Okay.
don't know what the value of this company is today. We're not going to negotiate it. Come in under convertible debt. You can convert at a later time, and we'll put a reasonable cap on the value of the conversion. So you are going to get upside, and it's just a negotiation.
Okay,